Evening, everyone, virtually and here in attendance. Going to start the meeting. Good evening and welcome to the Wednesday, October 5th, 2022 meeting of our Fitchburg Conservation Commission meeting. Please be advised, FATV is conducting an audio and video recording of this meeting for the public broadcast purposes. I ask that anyone else in the audience who is recording this meeting to please identify themselves for the record now by standing and stating their name and address. No one's recording. At this time, I ask all electronic devices to be placed in silence mode for the duration of the meeting. I'm going to conduct a roll call of the present members of our Conservation Commission. Commissioner Baker?
Here.
Commissioner Helene?
Present.
Commissioner Christensen?
Here.
Commissioner Donnelly?
Yeah.
And Commissioner Joyce?
Here.
Myself, and that makes 6.
Yep, and myself.
Here will be coming in about half hour, 45 minutes. He's delayed because of a work meeting.
Tracy's due to join us throughout the duration of the meeting, and Commissioner Bro is present. Aye. Okay, so now it's slide into the first hearing?
Yeah, sure. I can give some background on that. They requested another continuance.
Okay, so it does look like our notice of intent, Fitchburg Property Landowner, LLC, 366,000 square foot warehouse and distribution building in the riverfront area located at 0 Crawford Street, has requested a continuance to the November meeting. So we will slide ahead on our docket for the evening to number 2, notice of intent, Fitchburg DPW, repairs to Arbor Way retaining wall, which was continued from the 9/7/2022 meeting.
And Nick Erickson is here on that. I think we have another continuance, Nick?
We have you live,
Yep.
Nick?
Can you hear me?
Yep. Yeah, we got you.
All right, excellent. Good evening. Unfortunately, I do need to request a continuance for this project. We're working on getting the final draft together for it's just not quite 100% complete. So hoping that that's finalized within the next week or two, and I'd like to get it to you commissioners with plenty of time to review as well. So hence the request to continuance for next week, next meeting.
Okay, thanks, Nick, for that update regarding the retaining wall over there at Arbor Way.
In that next meeting, so the commission knows, and folks not on the commission, the regular meeting would be Wednesday, November the 2nd.
Okay. So, moving on to our third item on the docket this evening is listed as Notice of Intent, Barclay Enterprise, a new single-family dwelling, lots 1, 2, 3, and 8, located Sheldon Road, which is also a continuance from the September 7th, 2022 meeting.
Good evening.
Good evening.
Paul Grazowitz from Graz Engineering.
Hi, Paul.
Hi. Tonight we have the owners of the 2 properties. It's actually Barclay Enterprises, and also Mr. Sepula owns Lot 2. He's here tonight also. So the last meeting ended in some frustration. There were a couple of comments that we addressed on the plans that you now have. One was more riprap at the outlets, and another one was from DPW comment about the drain pipe going under the proposed slab, the garage slab. So we added a manhole, and that pipe goes around that proposed house now. The frustration came in more at the as a result of the ongoing enforcement, not against my clients, but against the owner of the land that they bought the land from. They bought these frontage lots, and there's an issue in the back land with whatever's been done out there. At that time, we talked about the continuance. I guess the commission wanted to do some more research on what their, what they could do or about the situation. And that's where we're at.
Paul, do you want to, I don't know, maybe that's, the first plan up is lots 1 and 2. So just in brief, what changed? I can
Yeah,
zoom in a little
there's a pipe, you'll see right in the middle, going between the two houses there's a drainage pipe. That previously started at the catch basin in the driveway, went directly under the slab,
Okay,
and it
like
went to that infiltration basin out behind those two houses. Tim had commented on it, and DPW commented on it, so we added a manhole to go around the house in case there was ever a future problem with that pipe. It can be dealt with without tunneling under the house, I guess.
And then the next couple lots over, this one would be,
Yeah, Lot 3, we added some more erosion control in the back. I think another row of siltation controls. And there's additional riprap on the outlet of that, from that pond we've got there. That was, up by the basin, there's additional riprap.
scooch up there.
That was the only change to that.
And then there was this third plan, but
Right, lot 8, we're calling it, which was number 80, Sheldon. I added some additional erosion controls and riprap at the outlet of that basin. It's outside the buffer zone, but Tim had a comment on it, so,
okay,
yeah,
Down
right
here.
down there.
Yep.
Yep.
gotcha. Okay,
Okay, so that's each of the revisions or modifications since last month?
Pardon me?
Those are the modifications since our last meeting?
Yes. Yes.
Okay. Is there anyone here in attendance virtually or physically at the meeting tonight from the public that would wish to speak on these matters of change from last month's meeting? Nothing
or
urgent?
if Tim has any.
Okay. So it seems like we have no public comment. I'm going to turn it over to comment from my fellow commissioners. Commissioner Baker and Helene, raise your hand if you'd like to chime in. Here on the floor of the meeting, we'll start with Joyce if you have anything.
Well, I want to say we appreciate all your patience and all the effort that you have put in, but as you're aware, there are still issues that are out there and a serious violation that occurred from the previous owner. You're going to hear from Commissioner Donnelly shortly about what he was tasked with to find other legal remedies against the previous owner. We know that puts you in not a good situation, but we have to find out whether or not if we approve your lots, does that reduce our standing with the previous owner in the remediation that needs to take place on the other lot? And I know Commissioner Donnelly can kind of go over what he's found out about that. But we appreciate your patience and we understand the issues, but unfortunately you kind of got wrapped up in this whole process.
Thanks, Joyce. Commissioner Donnelly?
Thanks for coming in, guys. We need one more party, but we'll, thanks for coming in, and don't mean to slow you down or to get in your way, but I'm going to respectfully recognize your lots as parcels 87R50, and that's the entirety of that side of the road, the south side of Sheldon Road. And in July, an inspection was made, and a violation identified, and it hasn't been corrected, and we'd like to get it corrected. And the fact, it was both, well, I'm going to say it's cagey to be able to subdivide your lots from parcel 87R50 and expect that all is okay. And that's not the case. I'm going to recognize the whole lot in its entirety and not the subdivision. And we're looking for compliance for the violations on the whole lot. And we have some due diligence to do, and that's what I did between now and then. What are our options? And it's clear what our options are, and now we need to follow them. So I can't in good conscience separate it 9 and 10. I recognize it as one whole parcel, and we'll continue with our enforcement order on the entire parcel. So were a vote to come up, I'd respectfully decline based on an outstanding violation on 87R50, and until such time as the owner of that property comes before us and gives us a remediation plan, I'd respectfully deny any applicant ahead of that. And you don't want to hear it, but sorry.
Is it a question of access? I mean, would giving the owner of the backland access?
No, it's not access at all. There's an outstanding violation, so it's a bit presumptuous for you to look for an approval on a application for relief when there's an outstanding violation on the parcel. And you would like, and you would like me to identify 9 and 10 as separate parcels, and I'm refusing to do that. I'm going to continue and be consistent in recognizing 87R50 as a parcel in violation until such that violation is remediated, solved and fixed. I'm not willing to take any action any further. I want the owner of the parcel in here. I want him to face the music, and I want a plan to restore the site to its former condition.
Just for the record, Michael, 9 and 10 aren't the subject tonight. It's 1, 3, 5, and 8.
Okay, I'm sorry. This addressed 9 and 10, and we may have already. I'm an open book. We may have already played our card by issuing orders on 9 and 10. So that might give you some relief there.
The two lots that I believe you're referring to, Michael, are 1 and 2 in this current notice of intent that we're reviewing tonight.
Yeah.
1, 2, 3, and 8.
Your lots, the lots before us, yeah. But at any rate, the parcel's in violation. Those are part of the parcel that's in violation. I'd like to correct that before we entertain any notices of intent.
Could I ask you when that enforcement order was issued?
It was
can.
well over a year ago, Paul.
Right, well, this was subdivided well over a year ago also. Mm-hmm. And my clients took ownership of it well over a year ago, I think. It seems like it.
Is Tim with us?
Tim is with us.
In July 31 in 2021, the parcel was walked, and at that time, 9 and 10, not yours, 9 and 10 were part of the larger parcel, and you subdivided ahead of 9 and 10?
No, we did them all at once.
Okay, so they were part of the larger parcel at that time. At least that's
All
what
the frontage lots were cut out.
that's what our agent informed us on his site walk.
Yeah.
That you were part of a larger parcel, and I'm going on that.
Yeah.
And Mr. Adams was well aware that this was going on, probably at the time that he was doing the subdivision and the parcels were put up for sale.
That's possible, I don't know. I've actually never spoken to the man, never seen him.
Unfortunately, neither have we, and so that's part of the issue.
So what do we do? Continue this to a,
I've got a couple of questions. Could I ask a couple of questions?
We actually,
Happy to.
Commissioner, I just have a few more commissioners to go on my roll call. Just real quickly, Commissioner Christensen, do you have any comments?
No, I'd like to let him ask his question.
Okay.
Stand here.
Yeah, that's fine. Yeah. Just state your name.
Yeah, Jamison Van Dyke.
Hi, Jameson.
So I completely hear what you're saying.
Thanks.
I guess the question I have is 9 and 10, the ones you were referring to, I think you're talking about 1 and 2. Because if you're looking at Sheldon Road, you're looking out at the mountain, 1 and 2 are to the right, 9 and 10 are to the left. So 1 and 2 are the ones that he has on the screen
Yes, sir.
here now.
Understood.
So 9 and 10, we broke off. They had notice of intents. We built and sold houses on those.
Yep. We have, as I stated, I'm an open book. We may have already played our card.
Okay, that's what I was curious about. Then we could look at when we subdivided these, but it was I think well before your site walk, where your enforcement order came on. So
at least 21.
yeah, it was.
It was January
Yes.
21.
Yeah, so these were, when you guys went out and did, like, we had already bought all these, right? We broke them all off. The only reason they don't all have houses right now is, we couldn't go and do the test pits at the time, due to, the heavy rains we had in that July, August of 21. So we had to wait until this summer to go and do them. They all tested, and here we are, but it took me 5 minutes to get a hold of that guy, and I've been trying to reach you. I've left 7 messages since the last meeting on your phone without one return call, so that's frustrating. And you've been great to deal with up until that point, and then I don't know why I've been ignored from that meeting until this meeting, because I was trying to help out. So that's frustrating. And we've been very patient, as you said, just waiting and waiting and waiting and waiting for these different meetings because of the landowner that owns everything in the rear. Now, the only lot that we broke off that he actually is in violation of is what we're calling Lot 3, the access road. So I could see you guys wanting to hold on that one, because that's going to be his access, and I'll give him access to get out there. But at the same time, you have runoff going. Like, that lot that was destroyed that we're trying to fix is still destroyed. We also sold 2 lots off to a different owner who's not here, that is in the field lots, which would be 6 and 7. I don't know if they're being held up, but that was all part of this piece as well. But he still has access through the actual house that he has. So he's got the farmhouse and all the land out back, and we're being, I feel like, held up when all we're trying to do is go and beautify and correct and fix everything that he did on the lots that we bought from him. So I can get you, I contacted the realtor that has the listing for him. So I'm like, hey, how do I get a hold of this guy? Called the realtor that's got the listing. He contacted him 5 minutes later. He said, yeah, he's calling his attorney and he's getting in touch with Fitchburg. So apparently, I don't know if he got in touch with any of you. That's what I was trying to figure out with you. But Rob Deschaines, or Mr. Deschaines, has the listing, and he's got contact with the man that you're looking for. But even if you guys could, I don't see why you can't sign. You already signed off on 2 of them, and these other ones were created well before the enforcement order on the backland. Even if you had an enforcement order on Lot 3, 9, 10, these other 6 and 7, I don't see how those could be tied into it when that was after the fact.
I heard everything you said, and I'm following you, and I want to help you back. It's come to our attention since the last time, and before that, and reinforced again that the violation goes with the land.
Right.
And it's new court precedent to that effect. So I'm kind of leaning towards that.
But the land, as you say,
You subdivided. You think that you did it ahead. Any information that I had was on this piece of paper in terms of when the subdivision took place.
so if you could review that, we'll wait till the next meeting, but if you could review that, I don't see how you can tie that to the lots that didn't do anything wrong.
So, Mr. Van Dyke, to that point, we understand how frustrating this all is. Commissioner Donnelly is going to present also, he was tasked last meeting to find out whether or not we can get an attorney to represent us on our behalf. He has done that work. We're going to talk about that probably in a little bit. And if we do, that's going to postpone the meeting for another month. We understand that, but we want that attorney to look at the entire situation. If he comes back and tells us that these were subdivided before and that, we don't have standing, well, he's going to come back and say, Commissioner Donnelly is right, the whole parcel, and it all goes forward as one piece, that violation still exists. So I guess the point I'm making is that I think we're going to be, again, one more month while we get the attorney that we talked about last month involved so that we can get some answers to say, what is our standing? If we approve your lots, do we lose our standing for the rest of it?
No, because he still has the house that's attached to everything.
Well, I understand that, and it's not just access, it's legal standing court-wise.
And let me run this one by you too as well. We'll take any pressure on the owner of the larger parcel from anybody willing to give it. And you guys have been extremely inconvenienced. And I don't want you to look at us inconveniencing you. We'd prefer that you'd be our ally in getting performance from him. So if you were to direct your ire at him and not us, that would help us resolve this too.
Who would be my point of contact? You, Michael, or?
No, not me. Thank you. Michael O'Hara.
I apologize. It has been crazy at work.
It's been crazy for me too, but I mean, I'm carrying a huge note on these, and I don't know if you've seen the news lately, but interest rates are going, mortgage rates are going, and housing is slowing. And that's the business that feeds my family, feeds his family. And so when I'm making these phone calls, it's not like, I mean, when I have ire, I have ire, and I am trying to be very pleasant because I feel as though I've been wronged, and I hear what you're saying. I hear that you got to talk to the attorney and get their complete opinion. I hear all of that, and I'm willing to wait another month as long as we can work as a team and go for it, because I don't want to wait another month and then come back. We just waited a month. We were going to talk to the attorney. Here we are a month later.
To your rep, I had a job to do in 30 days, and I did it, and I'm going to present my findings to these people tonight. And if it meant having legal counsel telling us what we were correct in doing, that wasn't my job. My job was to find some information, bring it back to you. So I'm not dragging my feet, because I know exactly the situation you're in.
Okay.
I get it. I want you guys as leverage to get performance from him.
Yeah, I feel that. All right, thanks for hearing me.
Thanks, Mr. Van Dyke. With all that being said, I do have 3 other commissioners, including myself. Commissioner Christensen, do you have comment?
No, I do not.
Yeah, we've heard a substantial amount of detail. How about Ralph or Commissioner Helene? Either care to comment?
I do have a comment.
Go ahead, Ralph.
I think that when you look at lots 1 and 2, the way they were carved out to kind of maximize the ability to put both of those systems in the way they did, that the fact that the 50-foot buffer goes right through the middle of one of the proposed houses, to me, seems like a big overreach. And I don't remember whether it came up last time, but it certainly when I looked at these revised plans, it stuck out at me. I mean, it'd be one thing if they were proposing for us to waive the 50-foot buffer, for something other than a house, but a house is such a major feature of the proposal that I just can't find myself able to ignore that. And that's troubling to me.
Thanks, Ralph. Commissioner Helene?
Thanks, Ralph. That's a great point. I guess this one's a really unique and tough situation, and now we're hearing about other lots. This has been subdivided so many times, and I wish that we could help out the folks that showed up tonight about these lots that are not so much of an issue. But I also hear what the commission is saying as far as recognizing the subdivision. And so I guess I'm just in agreement at the end of the day with Mike Donnelly and his findings. And I do just think that we have to stay diligent on this one, get that lawyer involved and figure out what we can do. And hopefully the homeowner shows up, I guess. It's really part of me thinks that we should recognize that, we should look at the date of when this subdivision happened, and if the lots that were subdivided prior to that site walk and the initial violation, if it happened prior to, but can we recognize that? And then at that point, we should probably have a site walk for the ones that they're asking for tonight, if that makes sense.
Thank you, Commissioner Helene. For my own comment, I do understand the frustrations that have built in the last couple of meetings over, the situation here on Sheldon Road. I do find it weird middle ground, legalese kind of. I don't understand why this mystery ghost doesn't have to kind of present himself before these discussions to help clarify some of these matters, but I do understand at the same time, too. I think that's why he's hiding behind it. But I do have to hold up to the findings of the commission over the last 30 days since our last meeting. Tim, do you have any comment, any further comment, at least, before we move forward with the motion?
I do. So, number one, I'd like to point out that the farmhouse, Mr. Van Dyke said that the Adams, the property owner that is responsible for the violation, still has access to the lot that the farmhouse is on. And I don't think that's the case. I talked to one of the neighbors who's got a lot across the street, and I believe he purchased the farmhouse. So lot 3 may be the only access to the backland without going over a significant section of wetlands. So that's why lot 3 is pretty critical to the restoration in the future, because it provides access to get because there's going to need to be heavy equipment brought in to do the restoration. And Mike O'Hara had noted that there is another access, but there's a significant wetland blocking the access. So lot 3 represents the only upland access to the area where the restoration is needed, from what I understand. Second of all, the point was made that Mr. Van Dyke said, well, the land was subdivided before the violation was identified. And I'm just wondering, what about when was the land transferred? So it was subdivided, but what about the transfer of ownership? When did that occur?
January of 21, just stated by Mr. Van Dyke.
This plan that's on the screen now was recorded January 19 of 21, shortly after.
Hey, this is Nick Erickson here. I just want to point out that this violation occurred during the summer of 2020, and it was reported to by me to the commissioner at the time and to the commission. So I applaud the commission for finally issuing an order, but the violation occurred much before the transfer of ownership.
Thanks, Nick, for that clarification and nuance. Any other further comment from my fellow commissioners? No further comment. How do we move to motion this?
Hey, Commissioner Bro, do you mind if I said one more thing?
Yeah, of course, Nick.
Nick Erickson here again, just for the record. So, as I just stated, the violation did occur during the summer of 2020, but the violation was pretty extreme. It was noticeable. It was not something that was not obvious. It was extremely obvious. So I would expect that a developer purchasing this property would have noticed this and looked into it prior to making the purchase. In my opinion, the analogy here is someone going down to a car dealership and buying a new car and it not having wheels on it and then expecting to drive it off the lot. That just doesn't happen. You know, you don't go down to the dealership and not notice if a car has wheels on it or not. So just my opinion on it, you know, this is an egregious violation of the Wetlands Protection Act. It's something that should be more than obvious to any developer or engineer or scientist that goes to the site. And it should have been picked up by the current owner doing due diligence on the property before buying it. That's just my opinion for consideration by the board.
Thanks, Nick.
But I think the point needs to be made, though, that 9 of those 10 lots weren't part of that violation, really.
Yeah, it's certainly a...
And so why weren't the current buyers, you know, filled into that, or how, and that's really where we need the legal expertise is, does the violation go with the property, which Mike has done his due diligence to find out that yes, and we're not going to recognize that subdivision until the violation is, you know, rectified.
Commissioner Bro,
or Joyce, any further comment from my commissioners is welcome.
well, while we're still on this and while Mr. Van Dyke, and I'm sorry, your name is? So they can see where our next step is going. If Mike could present the information that he found, and then we could make a motion on whether or not the attorney that he is looked into, and that if we want to get them involved, and so these gentlemen will know how we're going to proceed over the next month.
Yeah, I would agree that Mike's findings could help put some clarification to forecast this matter moving forward. Yeah. Go ahead, Mike.
I don't know that they will. I wanted to share this with you with no big secret here. Gregor McGregor is a renowned environmental attorney, and we hired him 100 years ago, 1984, and he represented the city of Fitchburg at the time. But he put the ball back at our court. He put the burden on us to number one, to get an enforcement manual for Wetlands Protection Act, and then get our documents in a row, familiarize ourselves with that manual, and call him for his services if we're going to hire him. So that doesn't put us any further ahead. Massachusetts Association of Conservation Commissions directed me to purchase the enforcement manual, and I found it online. The information that we got between last meeting and this meeting the Lawyer Weekly and another publication, there was a finding in the Supreme Court that the violations go with the land and the transfer of the land. The Board of Health in Fitchburg, I found, they were, I'm not going to say no help, but, excuse me, they're not allowed to fine violators. The building department, however, MGL Chapter 143, Section 94, one of their powers and duties is an ability to fine violators. Excuse me, Chapter 40, Section 21D of the Fitchburg Conservation Commission gives us the power to bring a violator to district court. It is pretty plain, it is pretty simple, and it's embarrassing that we haven't done so already. The Fitchburg Chief of Police, he has affirmed that he will carry out his duty as outlined in the Fitchburg Wetlands Ordinance in all criminal matters that we would bring to him. He would need to bone up on his environmental law prior to performing that duty. He doesn't have the authority to deliver complaints, notices, or serve papers. We leave that job to a sheriff or a constable. And all of these things I just spoke of could have been exercised by this Conservation Commission if we were on top of our game. The Treasurer's Office, they apply liens to property in the form of water and sewer, and they get settled at a closing, but they can attach them to the tax bill. And excuse me, I guess a buyer could accept that responsibility. So you always have the opportunity to accept the violation, but they get settled at a closing. So the Treasurer's Office and the Building Department can do things in-house. Let's see. I have an environmental engineer who's willing to run with our problem, one of which is yours, not all of which is yours, to follow up on violations. He'll make it his job and his duty, and he's well aware of the Fitchburg Ordinance. He wrote it. The Treasurer's Office confirmed to me that Adams R&R LLC has a mailing address of 112 Sheldon Road. Anything that's delivered to that address is considered received. The tax bill goes there. You cannot argue you didn't get your tax bill. You can't argue late payments or interest, the fact that you didn't get it, if it was mailed to the address on record in Fitchburg. So any notices that we give are received at 112 Sheldon Road in Fitchburg. And then the last thing I just shared with you tonight's not here. One more thing pertinent to my task. It'll come to me. I don't know what it is. So I don't know that that helps you guys at all. But those are the things that we're wrestling with. And another 30 days, I don't know that we're going to learn any more if we just hire someone to run with it. Let me float this. If we were to deny the applicants tonight, they have recourse. They can appeal to the state. They can also appeal to the seller. I guess they could go to court, and they could either take us to court or they could take the seller to court. And that may be where it's going. And as much as we have, everything that I read about was about going to court, district court or otherwise, to get performance from the seller. So we could take someone to court, they could take us to court, you could take him to court. Maybe that's where it's going to end. And doesn't help you, and that information probably doesn't help you either. You know?
We also had Mr. Van Dyke, who pretty quickly got to the bottom of finding the violator's number and getting in touch. What can we do or have we tried to get this initial landowner to cooperate with us recently, like in the past 30 days? What
have you done, Mary? Everything has to be in writing. From this point, we need a paper trail, and it's got to be in writing, so you can talk with them all you want on the phone. But
well, to that end, can I make a motion that, again, we're stating that there is a major violation that applies to that property as a whole, 875R0. Send that violation notice to Mr. Adams with the $300 fine that is our initial fine, and that needs to be paid immediately, and this office, your office, Mike, needs to be contacted. That's our place to start, to try to get his attention to contact us, and it's on record. And he's going to owe us the $300 fine. And let's try to contact him again. And if he doesn't reply, the fine is sitting out there again, and again, it's one more issue that needs to be addressed.
Legal language said that we had 21 days from that notification to file in district court.
So if he doesn't
That meets
respond in
a 30-day
21 days, we could,
A 30-day threshold.
yeah. So motion to issue a major violation with a $300 fine and have that sent out to the Sheldon Road address, since that's the address that we have, immediately.
I would run with it, but I think just ahead of that, they're looking for direction and clarification on their application. I think that precedes.
Okay.
Well, I think we've decided to handle the violation as a whole, as a property whole. And so if we're handling the violation in that manner, we need to get the original landowner involved. And so, I would like to see him at the next meeting.
Would you be amenable to another 30-day continuance?
Yeah, and I'll do whatever I can to try to get, I don't know if he's living around here.
Or he's not.
Or he's not.
The green card that we got from the violation notice from a year and a half ago now kept bouncing back, but with the forwarding address, it's an address, I was going to give that to you, Paul, because you're owed, I know. It's up like in Hamilton, up in that neck of the woods, Massachusetts. Don't quote me on the date, but I do have the green card.
Ghost is on the North Shore.
The 112, to respond to Nick though, 112 Sheldon Road is still attached. Like, he said, that we would be wise to know that there was a violation, before we proceeded. I don't want to go back and forth and fight with the board, but it would be wise for the board to have known that there was a violation when they approved 9 and 10. It would be wise for the lawyers, before they closed on those houses, to realize that there was no closing attorney picked up on anything. But 112 Sheldon Road, the farmhouse, is still connected to the whole violation. So the access that he's talking about that's not there is there. You can look right on the map. It's still connected. So they don't have to access through our property to get there. You can still access through his property off of Sheldon Road. The neighbor he's talking about is the neighbor that bought the other 2 lots from us that we had bought from him. That's the neighbor that owns the piece across the street too.
Okay.
So it is accessible. And the piece that Mike's talking about, when we broke it off, the developer had promised he would never build anything out back. So we made sure of it by taking all the good road frontage that was buildable and leaving the piece that was non-buildable, which is the wet piece that Mike was talking about. So in regards to that, you guys will never let him access that. It's all wet. But that farmhouse is very accessible to get to the violation.
So, Mike, your concern with a continuance is?
A continuance recognizes 1, 2, and 3.
But we haven't made a determination yet.
Continuance recognizes 1, 2, and 3. Maybe it does, maybe it doesn't. I don't know. I'm not a lawyer. That's why we need some help. But
when I say connected by same ownership.
Yeah, right.
Yeah.
There's a lot.
It seems like the records reflect that, so. Okay.
So Mike O'Hara, you've been showing us that according to the Fitchburg Assessor's Map, 112 Sheldon Road with the farmhouse in it is still owned by Adams R&R LLC at this time. Is that correct?
That's right.
Yep, Ralph, that's correct.
When you hover over the parcel, whoops, not now because
Yeah.
the name comes up.
I just wanted you to clarify what you've been showing us because you haven't said anything.
Still in the same ownership, like Mr. Van Dyke said.
To the applicant's point, if he owns it, that's access to the rearage.
Any further comment? I think maybe we maxed ourselves out on comments on this one.
I just feel as though the enforcement order could be very well addressed to like that piece where the problem actually lies. And I'll chase the heck out of this guy for you as much as you want. I'll call every day.
No one's going to say no, right?
Yeah, you're not going to hear a no.
I think it's an extension or a denial from this guy here. That's what it is.
For formality purposes, you won't hear us say go chase him, but yeah, track him down.
Well, like Mr. Van Dyke said, I'll contact the Realtor, and if they were willing to give Mr. Van Dyke a number, you know, we'll find it out.
It's like we said, yeah, that's a degree of leverage that can be exercised moving forward.
They actively are showing that property right now. They've had customers out there walking it, looking to purchase it. Yeah. It seems as though the city put a lien on it or something. That would be your leverage versus us being your leverage.
And if we can, we will. That was part of my research. You know, it would help. Dates of the subdivision, dates of your purchase. I don't have them in front of me. I don't know what they are. That would help. And I could go look them up, or you could go in. Those recorded dates. I heard you. It's not that I don't believe you, but I want. So I believe it's an extension or a denial, and let's make a decision for these guys.
I think it falls under a continuance.
So I have a motion on the floor to continue for 1 month while we seek the legal counsel that we talked about last month to get a definitive answer as to whether or not, if we take these out, do we still have standing with the whole property?
His instruction was to gather information. I just asked for information on dates in terms of the subdivision. That's something we have to provide for him. So we need our ducks in a row before he can help us. So that little bit of information is what we need, either from Mike, from you, or I'll get it at the registry.
So I believe
We continue this to the next meeting.
make a motion to that effect.
So I make a motion that we continue this to the next meeting while we seek legal counsel.
Second the motion.
Commissioner Helene,
Aye.
Commissioner Baker,
Aye.
Commissioner Christensen,
Aye.
Commissioner Bro, aye. The motion passes for that continuance. Thank you, gentlemen.
So now the second motion would be then to go back after Mr. Adams with another notice of violation and a $300 fine, as is allowed in the Wetlands Act. And he needs to respond. We have it now within 14 days in our new environmental protocol, the enforcement protocol. And again, let's try to get that going. So motion to issue a major violation with a $300 fine.
Have a second?
I
Second.
second.
Commissioner Helene,
Aye.
Commissioner Baker,
Aye.
Commissioner Christensen.
Aye.
Myself, Commissioner Bro, votes in favor, aye as well.
So now the
Is
third,
that,
Yep.
just if I can get clarification, is that a one-time fine of $300 or is it $300 per day?
right now it's 100, it's one fine. If he doesn't respond within 14 days, as I understand the Wetlands Act, then we can enforce a $300 a day fine for non-response.
So it's a reoccurring after a 2-week
After
period.
14 days
For clarification, okay.
For each violation.
for each violation,
Okay.
yes.
And then see if you can attach
And then that now has monetary implications, which can later be turned into a lien, which we still need legal counsel on, but, so the next motion becomes hiring the attorney.
Well, again, he said, do what we have to do before we go after him, before we hire him. There's a time period, I believe it said 21 days. Inside of 21 days, after that notice goes out, we can file in district court. Let's do it. We could have done it a year ago. And if this body gives the job to Mike to do it, get it done. And if it's not his, if we have to hire someone outside, fine. But filing in district court it's a routine procedure. It's done every day.
So why do we want to wait? I mean, I understand he has 21 days to appeal, but why not get the lawyer on board now?
The requirement is ours after he's been notified within that time to bring him to court. The burden is on us, not on anybody else.
But we're not hiring the lawyer just to go to court. We're hiring the lawyer for general review of what our standing is.
I've said multiple times up here to get legal counsel, and we haven't gone anywhere. And now the legal counsel simply told me that we have to give him documentation that is required, and then he'll take that and he'll represent us. We need legal representation when you go to court. You don't necessarily need it before then. And the manual's there. You can read it. Mike can read it, and Mike can do all of this. If it's any layman, I guess, can do it, but when you go to court, that's when you need an attorney. Hire them. We got the money, hire them.
No, I guess I understand your point that you're making about hiring him if we go to court, because then we do need legal representation. But right now, we need legal analysis of our standing. That's the way I look
And he
at it.
can't give it to us without without the information that I'm asking from him, dates of subdivision, et cetera, of violations. So I have Tim's violation sheet. I didn't have that last 30 days. He may have given it to us. I didn't have it. And so those are the things that we can get together and then
So
give
we
to an
can turn
attorney.
those dates around quickly
I'll email the dates.
to Mike,
Mike has
We can
them,
go,
I'll email
yeah.
just to make sure that what he has coincides with what you have.
Mr. Van Dyke?
Right, and we could present that to the attorney.
It's all public.
Okay.
And there was one comment by one of the board members, I don't remember who, but it was about actual design on.
I cannot hear you, sir.
Oh, yeah, if you want to take the podium. Thanks, Ralph.
Sorry about that. There was, one of you guys had talked about on lots
Yeah.
1 and 2, that there was a piece of the house that was within the 50-foot buffer. I don't know if it was a garage.
Let me get that up again.
Oh, Mr. Baker, is that something that you would like to see? Would you like us to turn it into a one-car garage on that lot, or to get it out of the 50-foot? Nothing?
I think that would be something that would certainly change things, but the way the plan looks, actually it doesn't distinguish what's the house and what's the garage. It simply shows a building, and half of the building is inside of the 50-foot wetland buffer, as presented to us today.
Okay, I can try to minimize the size of the house on that lot to help alleviate that.
We're getting on the screen again, Ralph.
Yeah, so as you can see, in the middle of the drawing right there, proposed 3-bedroom dwelling, and it shows the 50-foot wetland buffer going right through the middle of the house. You just, yeah.
Yep.
Oh, yeah, I see it, yeah.
Yep, right there.
So it's allowed but not preferred?
It's only allowed under a waiver from us. It's actually,
Okay.
according to the wetlands ordinance, it's not allowed. Your consultant should know that.
Yeah, I hate to disagree with you, but you have a 20-foot no disturb and a 25-foot no building zone. And that was designed to stay outside of the 25-foot. There is no 50-foot
To be honest, Ralph, I think the engineer was showing that just as an example. You know,
The 50-foot is on there because of the septic systems. That's Title V. But it's really got nothing to do with your bylaw or the Wetlands Act, for that matter.
Well, if I'm wrong, I stand corrected. Tim, could you please?
No, yeah, it's true. I think because it's there for Title V, it's causing a little confusion. It is a 25 and a 20-foot buffer for the no build and the no disturb zone.
Okay, thanks, guys. I just wanted to make sure, I just want to be focused on this one big issue and not get through this and have other hurdles to jump through afterwards, so.
Understood. I stand
Thanks.
corrected.
All right, thank you.
All right, so now I'm trying to catch up. We issued the continuance, so we're going to continue this to next month. We're going to issue the new violation and send that out. And we still have the attorney, which I will still put a motion on the table that we, Mike O'Hara, Mike Donnelly, if you need some help, I will help out with that we start the process of retaining Mr. McGregor as our counsel, not just to defend us in court, but as counsel as need be with questions that we have. What is our standing?
I support that facilitation moving towards the next meeting too, so that this can gain some ground instead of standing before this commission at the same idle position for much longer.
MACC has a number of attorneys available. He's the most expensive and perhaps the best, but there are others. So rather than legal counsel, yes, specifying who, not at this time.
When will we make the determination who and when?
We best get back together with information and put our package together, dump it on him, and let him run with it.
So that we don't run into the 30-day period. All right. So the motion would be is
14 days.
to put together information to retain outside legal counsel as regards to this project, and very quickly, either an executive committee or an executive meeting will be held to determine who we want to hire.
I have a question. I have a question about this potential motion.
Go ahead, Commissioner Baker.
Does anybody know whether we have to go through the city's procurement rules
It's a good
to
question.
hire this
Ralph,
counsel?
we can clear that up with the purchasing agent, but I believe that the city solicitor has a separate account because oftentimes he needs additional help with an eminent domain case or a tax title case. So he might have the flexibility to do that without, for example, going out to bid or entertaining whatever proposals from individual.
Exactly. That's what I'm wondering about, is whether we would run awry of the city's procurement rules or not, if we were to hire somebody sole source as opposed to going through a competitive process.
No, I can check with Mary, purchasing agent. We go right by her office every day, a dozen times.
So Ralph, if I change the motion to if allowed within the city regulations, we could go out and obtain
How
our
about
own counsel.
we will be seeking legal counsel either through the city or through private means in an executive meeting held within whatever time frame.
Okay.
That seems like a better plan.
Yep.
Yeah, it does. So we'll do I have a second on Mary, Commissioner
Second.
Haynes?
Second.
Yep.
Commissioner Christensen?
Aye.
And I believe I had concurrence there from those two, so I vote in favor of that as well on that motion, so aye. That concludes those three matters regarding this docket item. Thank you, gentlemen.
Tons of fun.
Thank you very much.
Thank you.
Oh, more paper.
All right, moving forward, notice of intent, Ridemore Heavy Duty Truck Parts, located at 150 Benson Street, Fitchburg, Mass. Address, wetland violation.
Yes, good evening. Patrick McCarty, McCarty Engineering.
Good evening, Patrick.
So just wanted to give a little background here to the commission. So obviously, we're aware of the enforcement order that was issued. Mr. Pomalu originally hired Alton Stone to prepare the notice of intent in response to the enforcement order, and he's decided to switch to our firm to help handle the notice of intent through the commission and to a resolution. That being said, we've only been involved for about a week. We have gone out, we've looked at the site on both sides, toured the site with Mr. Pomalu, reviewed the documents that were submitted, but in respect to the commission, whether I agree or disagree with what was in the documents, I didn't want to change or resubmit anything from my firm without first coming and discussing with you, because I didn't want you to have one thing in front of you and then have another thing in front of you. And so that's why I'm here this evening. And also, Mr. Pomalu sends his apologies that he's not here this evening. His elderly parents are in Cape Coral, Florida, who got hammered by Hurricane Ian, and he's down there helping them out with the damage to their home and the loss of power and everything. So he sends his apologies this evening. So really what I was hoping to do this evening is, so we are aware of the violation. He takes responsibility for the violation, wants to work with us and you and Mike and Tim to come up with a resolution. So I was hoping just to have an open discussion with the commission on what we think the best resolution would be, seeing that this is kind of a unique site where it's steep slopes down to the perennial stream. And so what really makes the most sense here? It's not where we have a flat backyard and somebody filled in a little bit of wetland that you could simply just walk an excavator in and reclaim and restore that wetland. It's some pretty significant slopes that have been armored. And so just wanted to discuss that. We also did receive from Mr. O'Hara this afternoon a second copy of the enforcement order and the fine for the $300, which we'll make sure will get paid, and obviously we're here to address it within the 14-day period and want to work with the commission to come to a resolution that makes sense for everybody and for the interest of the act. So I guess with that, I'd be happy to start a dialogue and see what everybody's thoughts are.
Yeah, Mike, do we have anyone from the public in the room?
Let me see here.
Initial
Patrick,
comment?
we know for sure from Alton that the hearing notices were sent out.
Oh, thank you, Mike, for reminding me of that. So in the package I received from Mr. Pomalu, I did have a notification to a butters form, but I did not receive any copies of the certified mailings going out or green cards coming back. So one thing I think would make sense for everybody is, assuming this is continued this evening, which I'm sure is the direction we're going to go, in between this meeting and the next one, I'll either track down the cards that if they were sent out, or we'll make sure that one of the guys in my office gets new mailings out so that we have proof of notification.
Okay, good, thank you.
Thanks for that procedural stuff.
I'm trying to see if we have anyone.
Mr. Chairman, can I?
Of course.
Do two things.
Yeah.
One is, in hindsight, I didn't want to discuss informally the situation 30 days ago because we had an NOI in front of us, but apparently we didn't. While it was all prepared, it had not been submitted, et cetera.
No, it had been submitted, Michael. The reason the hearing couldn't open because hearing notices weren't sent out by the applicant's engineer at that time.
I was adamant about not listening to it. We use that, I guess, as a formality, but I didn't want to hear. Actually, yeah, I thought if it was formal, we couldn't do it legally. If it was informal, I guess we could have done it. I started to apologize to say I was under the impression that it was informal. We could have listened, but. And then just my second comment tonight is that I wasn't interested 30 days ago, and I'm no more interested today. If there's a violation and a fine and it hasn't been paid, I think it's a lot to expect that we talk about it money talks, so if I saw a check for $300, I might engage you in conversation.
Well, respectfully, Mr. Donnelly, I can forward you a copy of the email received from Mr. O'Hara.
It was this afternoon, Mike.
4:45 this afternoon with the fine. So, respectfully, sir, I don't think that's a good way to kick this off.
As long as the applicant's current engineer is here, I think there's some value in not wasting anyone's
But
time
if
and
you'd
get
like-
towards a resolution of this.
If you do feel strongly about that, I'm happy to request a continuance right now. I'll see you in 30 days, and we'll drop off a check tomorrow to City Hall.
I would like to get
I'd
my
like to,
fellow commissioners to weigh in on it.
I'd like to continue an informal discussion.
I would like to continue in it. You're coming here in good faith to try to get a good picture of what you need to do to rectify the situation. We're not filing an NOI to move forward on anything. We just want to have an open conversation about how to fix the violation. I'm more than willing to have that conversation so that you can get your ducks in a row and have that as part of your plan next month. If that makes sense and we're all on the same page, I hope that Mike or anybody else feels okay about that, because that way you have a direction.
So, thank you, and just to be clear, so a notice of intent was submitted for this property by a different engineer who we have since replaced.
Gotcha.
And that notice of intent really was just a notice of intent after the fact, identifying the work that was done in the various resource areas, being the buffer zone and the inner and outer riparian zones of that unnamed intermittent stream, perennial stream.
So that notice of intent really would have been asking for us to approve the work that was done as is.
Correct.
So my interest right now,
Well, potentially, but you don't have to.
we don't
approve
have
it as
to,
is.
exactly.
Right.
So, Mr. Smith, Tim, I'm going to put you on the spot here. If this project were to come, any applicant came before us wanting to do the work that Mr. Pomerleau did as an infill in the wetlands, what would you expect that plan to look like? Or would it not be acceptable because it's too close to the wetlands? Is there a plan that's viable?
Well, first of all, as a starting point, what the Wetland Protection Act says is if land is altered illegally, it's in violation of the act, the land needs to be restored to its original condition before the violation occurred. So that's a starting point. Now, the Conservation Commission can look at it and say, well, yeah, but we probably would have approved, if a notice of intent had been filed, we probably would have approved X. Then they can accept X. But again, as a starting point, the act, the Wetlands Protection Act, says restore the site to its original condition before the violation occurred. So that's a starting point. To answer your question directly, well, the first thing, right, is we'd want to see a plan that shows that they meet all the performance standards. So over 5,000 feet of filling occurred, right, and there was alteration of the bank, and so we'd want to know, quantify how much bank was disturbed, how much filling occurred. Was it more than 5,000 square feet? So the whole purpose of the plan, right, is to show that the project complies with the performance standards in the Wetlands Protection Act. So I hope that answers your question, Joyce.
I think so. I'm just trying to give McCarthy some place to go. When they present a plan to us next month, it can't just be what's already there. Because I think, we probably are not going to approve what's already there. So now do we take it all the way back to the starting point, which legitimately we can do because it's in the Wetlands Act, as Mr. Smith pointed out, it can be required that they restore it back to what it was.
Correct.
But you're going to be tasked now to give us something that you want us to approve so that we can look at both features, going all the way back, maybe this is in the middle, or this is where we are, and that's going to be up for discussion.
Right, and correct. And I don't know if you did see the plan that was submitted with the Alton Engineering Notice of Intent. Mm-hmm. So it does somewhat do what you're asking for. Not saying that they didn't commit the violation, but the one smart thing they did as part of committing the violation is they at least put up hay bales and silt fence on either side of the perennial stream. So they didn't work in the stream, so there was no bank alteration. And it doesn't appear, and I will take another look between now and then, that they actually did any direct resource area impact. Well, and Tim's probably going to correct that statement. They did work in the riparian zones, which is technically a resource area. So they didn't work in the wetland itself. They didn't interrupt the stream itself. So, to your question, could this plan have been approved if it was submitted before the violation? I'd have to look in detail, but probably maybe with a little massaging.
But their intent, then, they knew that they were working in a wetland area by putting up the hay bales and the silt fence, which should have implied that somebody in City Hall should have been contacted.
No, and and he understands, and he's, I made a mistake. I want to work with the city to correct it.
Why was the NOI not submitted before the work was done?
I think in short, the engineer was called after the fact.
Right. Yep.
That's a good question, Mary, because it's like not only the NOI, but apparently nobody, Mr. Pomalu, I understand he's saying, okay, he understands that this shouldn't have been done, but he didn't go to the building department, he didn't go to the planning board, he didn't go to the conservation commission,
and I
he didn't go to anybody.
I agree, right? The correct thing to have done would have been to hire an engineer and a wetland scientist and a surveyor and put a plan together and file a notice of intent and obtain an order of conditions and all that good stuff. The reality is that none of that stuff happened, which is why the enforcement order was issued and why we're here to hopefully come up with a solution that makes sense for everybody.
I mean, my initial thought, unless there would be a better plan put forward where you're replicating wetlands, is that I would want to see that this is brought back to initial state, and then an NOI is filed, and then we could move forward. I mean, I guess it doesn't make sense to do all that work if we would have approved it, but I would have personally had a difficult time approving this project. So that's where I'm at as a commissioner, and I don't know, and I'd love to hear fellow commissioners' thoughts.
Well, I have a thought that I'd like to share with you, and that is that it seems to me when we did a site walk along the Twin City Rail Trail going past this property, we observed a violation that was going on then, and that was like, 3 years ago? So this is not the first time that this property owner has basically just done whatever they please. Does anyone remember that?
I do, Dave, Ralph. There's two reasons people do this, and I guess the two reasons I might do it. One is because it's faster. Government will slow you down. So he went through the motions. He did what was expected, in some respect for the resource area. And what was the other one? The word is out. It's better to ask for forgiveness. So those are the two reasons that I would give for myself, not for Ardmore. I understand them. Mm-hmm. We slow people down, and the word is out that we'll get their forgiveness because they're easy.
Yeah, but regardless of the motives or intentions, we are where we are, right? So he's owned up that it's a violation and knows that he has to correct it, and he's hired us to work with the commission to come up with the best plan moving forward. And to come to a successful resolution of it. And that's why we're here
And-
tonight, to have an open dialogue and
This is-
get some input from the commission before we just draw something and submit it. And
So this land was filled in for what, trucks to park on?
yeah, so it was already, that you could see on the plan that there was like a
Yeah,
kind of
whatever
a
that was.
lean-to structure, and it had parking next to it already that was regrinds. And
Yep.
essentially, yeah, just filled that slope out and
Yeah.
rip-wrapped it to extend that parking area slightly.
And it was filled in with what type of material?
Like a sandy gravel material.
And then
Okay,
riprap on
so-
top of that.
Yeah, with a riprap on top.
Right.
Yeah.
Okay. Yeah, heavy machinery, over time, that's something that, again, now we're on a banking or we're, near wetlands and we're going to be creating, issues with large machinery. So, my thought as a commissioner is that, like, I personally would not have loved this project for extra parking in a wetland. And so, my thought and again, just as an open discussion, is that, I would ask for this project to be like remediated unless the conservation or unless you guys can retool the plan that it somehow makes sense and we have some remediation going on at the same time. But that's just, again, I'm only one person. That's sort of where I stand as a conservation member.
So, as Mr. Donnelly said in the previous hearing, he's an open book, right? So my initial thought when I walked the site was the violation that occurred on, we'll call it the main business side of the site. That was a steep slope to begin with. It's still a steep slope. Now it's armored. It's stable. To take it all apart, you'd only be taking that steep slope and moving it back to a steep slope. So it really wouldn't be a huge improvement in my eyes to put that side back. And I asked him frankly, I said, what's the point of the Brattle Street side? He says, I don't know, I was just making it flat. And so there's a lot less change in elevation from the stream to the Brattle Street side than there is from the stream to the business side. And so my initial thought was to take all of the Brattle Street side out. Take the slope back, cut that whole area back, and really get rid of any parking over there and just establish that as a wetland and its buffer. Yeah, exactly, where that cursor is. And I said that to him. I said, what was the point, the thought here? And he says, well, maybe some expanded parking, but it's not directly accessed from his operating business. So to me, that made sense. It's less exposure, I guess, is what I'm trying to say, to the resource area to go in and pull that area back than it would be to take apart that huge slope that's now armored and stabled, and there's growth all along the stream at the bottom, than it would be to go in there, I guess.
But to Mary's point, we don't know whether or not we would have approved that to begin with, just for the sake of, that those trucks have oil, they have gasoline, there are issues. The further away from the wetland that you can be, the better. Whether or not we would have, even if a plan had been submitted that might have been acceptable if we would have approved it. I think going forward, I would like to see two plans. Is what would it take to take that out of there and put it back, because that's what's in the Wetlands Act, that the land needs to be restored, and then a plan submitted for what should have been done in the first place. And then we'll decide whether or not there's something in the middle or if it just needs to all be put back. We're talking about, I visited the site a few times, and these are approximate. I've taken some electronic measurements, and we're talking about on the Ridemore side, he has come out 35 or 40 feet, encroaching on the wetlands from where you go back to where is the original lot now. There's a lot of fill been put in there.
Is that, I sense a dual motion there for proceeding forward with this?
No, I don't, because we're not really in a hearing, I guess. This is just sort of an informational thing. So, we're trying to give and I'm sorry, what was your name again?
Patrick.
Patrick.
McCarty.
To give them some insight into what do they take for plans, what do they present to us as a notice of intent next month. And you may, I suppose I'm saying, if you're going to do this, and we have the very real possibility of saying to Mr. Pomalu that he needs to restore this wetlands, you may as well be prepared to do that and show us why he shouldn't be.
Yeah, and I think, I agree, and I think the third plan would be this as it exists today, right? So there's three options.
Maybe with some modifications.
Right, as it exists today.
Something in the middle.
Right.
Can we, and that's assuming, can we document that as it exists today meets the performance standards, right? Option two, like you said, is putting it back. And I do feel that would warrant some discussion, primarily on the Ridemore side, and I understand 100% what you're saying about the trucks and the fuel and hydraulic oil and all the stuff that comes along with trucks. I would be concerned, that's not a small undertaking, right, where the slope is constructed and armored and vegetation is reestablished at the bottom. Don't know if that makes sense. If that slope was opened up and we got a big storm coming through, it would likely result in a bigger nightmare than what we're looking at. And then I guess the third option would be something in the middle.
And I do agree with you as far as the stabilization that has been done, but you say as it meets the performance standards today, and it does not meet the performance standards today, and it has not because there was never an NOI filed and, initially, and it still is a major violation. So, if it comes down to wetland replication being the thing that that we vote on, then that plan will have to be undertaken very seriously as well.
So and I agree with you. I think on the Battle Road side, that needs to come out. That just, there's really no question. There's no rhyme. There's no reason, like you say, because he wants additional parking. He doesn't even park over there. It's not connected to his property. That just needs to come out. So you need to work with him to put together a plan to take that out.
And to be clear, and Patrick alluded to this, the resource area is the 200-foot riverfront area. So the 200-foot riverfront area, it's a resource area. Mm-hmm. Just like if land underwater or a pond is a resource area, or bordering vegetated wetlands is a resource area. So we're not even talking about, although there is a buffer zone to a perennial stream, but there's also that 200-foot riverfront area, which has the same status as a resource area. So it's any work that occurred within 200 feet of that perennial stream.
Right.
Right.
And and the question is that work that's within the 100, is that 10% of the total riverfront area on the site? I don't know. I haven't.
So Patrick he just alluded to one of the performance standards for working within the riverfront area. So those those are the appropriate questions to be asking.
Thanks, Tim.
Patrick's burden is to pre-existing condition.
Yep.
Give us what it looked like.
Yep.
And then the quickest, easiest, best thing for him to do, not telling you, but is to justify what was done, to convince us that was a good plan. That's all. If you can do that.
That's what I was suggesting.
Yeah, if he can do that, then he's done his job. And if they have to make some concessions on that plan, if he doesn't get all that he wants on existing conditions, then that's the third plan, a restoration. That's it. But an agent told me a while ago, would we have approved it if he'd come in? So the idea of removing 100% of it and restoring it, if we had approved it, that would be rather punitive. I wouldn't do that. But just convince us that what's there, if you think you can, and that's the quickest, fastest way to resolution.
Yes,
Did any of this fall in the endangered species habitat?
Not that I'm
It's
aware
not
of,
on
no.
the natural heritage.
And on,
I don't believe so. I'll double check.
Well, that'll be in the NOI.
Correct, yep.
And please work with Mr. Pomelo to get that fine paid now that you're working.
So
with
as
them.
I said, he's in Florida taking care of his elderly parents who got hit hard by the hurricane, so I'll pay that. If it's acceptable to get a check from my company, I'll pay it tomorrow.
You went to your back pocket. I thought you were going to pay it tonight.
I can go in the console in my truck if you hold on a minute.
Patrick, one thing, because I'm looking at the NOI now and the figures of, well, the total alteration of riverfront is almost 21,000 square feet. But I think Alton might have made an error in the total amount of riverfront area because, or there's either a ton of riverfront area or he misplaced the comma because,
Oh, it's 722,000 square feet. We're fine.
well, 722,9224.
I just
Now, how do
stamped
you-
that. We're good to go.
Everyday mistakes, right?
Okay.
Yeah, there is a large area, right, because it comes out through the existing building, but I don't think it's 700,000 square feet.
If you take out the Battles Road piece, I mean,
Right. So
that reduces.
I guess the moral of the story is that, we've been brought on to come up with a resolution. We want to work with the commission. We understand that it's a violation. We'll take care of the fine. And, this won't get dragged on like the previous hearing. We'll come to a swift resolution working together.
Okay.
Thanks for coming before us with
Okay.
the open discussion.
Thank you.
Yeah,
So
not everybody
do we need
takes
a
that
motion
approach.
to continue this to the next meeting, because we had it tonight?
Yeah, I think just because it's listed on your agenda.
Right, so I think we need a motion to continue this to the November meeting.
Do I have a second?
Second?
Just ahead of that, can we do a site walk so that we have a feel for what we're talking about instead of a two-dimensional plan?
Yeah, let's put that in our email chains, and we'll come up with a date, but we'll probably move forward with this motion at the moment.
Do the motion first, and then we'll.
So motion to continue this to the November 2nd meeting.
Commissioner Baker?
Aye.
Commissioner Helene?
Aye.
Commissioner Donnelly?
Yeah, aye.
Commissioner Christensen?
Aye.
Commissioner Bro? Aye.
You can set on a site walk now if you'd like.
Motion to have a site walk. That's, we're going to convene
Okay,
the
pick a
meeting
date.
until the site walk. That was my point.
Yeah, so because if possible, if Patrick can be there, you
Oh,
can.
I'd like to join you only because there is heavy equipment and trucks and stuff like that.
Well, you
so-
can see it better from the Battles Road side.
Joyce is right.
Because you cannot see it from
So you just
Broadmoor's
pull in
driveway.
off of Battle Street on that little grindings, area.
Into the
eight
parking area.
grindings.
Yeah.
Exactly. Bed-Stuy's on your right, on the opposite side of Battle Street. Next week sometime?
In all honesty, I'm not going to be able to make it, so I'm going to leave this to my fellow commissioners to select a time slot for this.
What works for you? Pat, you're working.
Yeah.
I could do next Monday. I could do next Monday anytime after 5. That's pretty much the only day next week
Not
that I
sure if we post a meeting, if we have a quorum, just to be on the safe side, post it. In case you do have a quorum, I don't think you can have a meeting on a holiday.
Oh, it's
We
a
could just
holiday?
get there
Oh.
informally,
It's
though.
Mary, can you do Tuesday?
Indigenous Peoples' Day on Monday.
No, I won't be able to do next week any other day except for Monday. I'll be working late in Merrimack.
But do we have to have a quorum? We're not going to be discussing
No. I
the
mean,
meeting.
Any one of us can go
It's
individually, go on
informational.
our own.
Right, I've been there several times, but it's good to all be together and everybody has questions, but
There's just no
Yeah, I can try to take a
deliberation
sip
during
Right.
it. You're just looking,
it's just informational. So then we could,
pestering Patrick.
so then we can
Why does
still,
it have to be next week?
It could be the following.
I just thought with time's getting short in the afternoon if people are doing it after work.
Mary,
No, it
how's the
is, but-
17th for you?
That's great.
Can we do Monday, the 17th can you be there for 5:30?
Yeah.
I cannot.
I cannot either.
I can do any day the following week. Next week, I'm pretty booked.
So what's better for Ralph and Mark the week of the 17th? Ralph, when are you available?
Oh, God. Friday?
Friday? It's Friday. This Friday, Raul?
No, the Friday after.
That Friday would be the 21st. Patrick,
That's
are
right.
you?
Right. I could also do it Friday, the 14th, but I don't know if others can.
I could do the 14th.
Mary, you're not available that week, right?
Friday, well, no, I wouldn't be. I'm sorry. I could do the following week. Fridays are difficult, but I will.
If folks take a drive down, it's pretty obvious.
Yeah, I mean, I could just take a drive as
I know,
well.
but
if that works for you.
I know,
Yeah.
it's good to have Pat.
Just, you're gonna bring in a plan, as long as you have a feel for the area. The plan will give you the numbers, the plan will give you everything, and you retain elevation and distance up here.
Yeah, I've already been there, done that.
Yeah, you're comfortable.
Yeah.
And just, everybody
But-
get comfortable ahead of the next meeting, so some of the questions will be answered ahead.
Fill oneself in on the finer details ahead of next month's meeting.
All right, so the site walk is off.
Off, no problem.
Okay.
On your own. If anybody wants to have me meet them over there, you have my email, cell phone, let me know. Happy to
Thanks
do it.
for providing that as a resource.
Sure,
Yeah.
anytime.
All right, so we still have did we vote on the meeting to continue? Okay.
Yes.
We did, yep.
All right.
Great,
Thank you.
thank you very much.
Okay. Thank you.
Forward to our other business section of our docket for this evening. First on that list is policy on enforcement of wetlands violations, which is a continuation. Any of my commissioners wish to speak on this other business matter?
I wasn't sure whether there was anything more that Michael or any of you wanted to.
Did we ever vote on the final proposal that Mike submitted?
I believe so.
Huh, yeah.
I believe so, yeah.
In the August or September meeting, correct? So this is now in place. The last proposal that Mike put together is the structure that we're working on as we go forward.
Yep. That'll be our rubric.
That's what I have in my notes from last meeting, yeah.
Okay.
Thank you for your work, Mike.
Yes, thank you, Mike.
Agreed. I appreciated those considerations on Mike's behalf.
We will convey
For our
that to
commission.
Michael when he comes back
Yeah,
in the room.
yeah,
He's
sure.
chasing down a $300 check right
Yep.
now.
Yep, okay. So, Woodland Estates, Mike, wetland replication update?
Yeah, oh, damn it, there was an email string.
There was.
Son of a gun, and now I think I have to log in again.
Ma, I told you I'd get it.
Let it be known. It be known.
Let me get it. Let me get this back again.
No, we just, your enforcement policy is all enacted. That's the process.
That's our rubric
So now
moving
we're up to
forward.
Woodland Estates,
It's reinventing the wheel. It's in the manual.
but that's
We
okay.
moved on to the
fine.
Woodland Estates.
Yeah, let me,
I'm gonna do the same thing.
hold on, sorry, I got out.
It's all right, Mike.
I need to get back onto work email, and we'll find it again. Got it, okay. Get at that Dropbox. There. Okay, other items. Okay, now let me get this up.
Crawford Street? Yeah, that was good. Real.
Oh, coming up.
Share.
Were you at the airport? Did you go with us to the airport? No. So the guy says that, the seed costs like $100 a pound for wetland mix, because they hand-pick the seeds. It's lush. The wetland detention, not detention ponds, a wetland restoration abutting the natural river. Lush. So a lot of sweet wetland plants that I didn't recognize, but it was nice. You were asking us to sign off on that tonight,
Right,
the runway expansion.
yeah, I do have that.
You're seeing, you're saying non-native species that you've never seen flourish before in our?
There was no.
Native.
They're all native.
Okay.
And then we saw just a hint of purple loosestrife. But he had some plants in there that looked like purple loosestrife that weren't purple loosestrife. So it's kind of go pulling all that out.
Speciation,
Mistake.
yeah,
I don't know
no
what it is, but I got an education. The guy was a wetland plant scientist, specialist. And he pointed. It was a learning experience for me, and I don't usually care about
Walked
something
away
like
gaining
that,
a
but
few
I did.
things.
So are we back?
We're back to Woodland Estates, yep.
Mary Ann DePinto was the wetland scientist on this, and she sent a couple of pictures of the relocated replication area.
Thank you, but I'm all
So that's on the screen right now. It was, if you recall, further up. Actually, let me go back one, because there is a plan. Okay. It was from a couple of weeks ago. They rang the entire new application area, replication area with hay bales. And that's her report, proposal to move it in area 450 feet. Let me get back to the plan that the commission had reviewed before, that was done by Whitman Bingham. Come on, go back. So this is the one that Jamie had presented back in the summertime. The previous wetland replication area was located further to the bottom, like way down here. So I'm not sure if that has been planted as of yet. And I meant to take a ride out there to see if this proposed wetlands replication inside the hay bales had taken place or not, but I don't know. And I don't know if anyone else has been.
I haven't been up there, but the picture that they sent us, isn't that supposed to represent what they planted, or?
Well, it was attached to the email from Mary Ann, and it looked like.
Which is why we were hoping to
Prior
have
to.
someone here tonight to explain what we're looking at and what was done. And not only is it the wetlands replication, but the detention pond was in Tim's order of conditions to be also concluded by November, the detention basin. And I haven't seen anything
Right.
that they sent us on that.
Okay, this is all I have from Mary Ann. So this, from the email from a couple of weeks ago, that was obviously prior to, and I'm not sure whether the planting has taken place there yet, but I'll check on that.
That would be helpful.
So can we send them a notice to appear at the next meeting?
I'll
Because
give
everything
Jamie-
needs to be done by November 30th, so
Yeah, I'll give Jamie a call. We're talking a couple of times a week.
and we need information on the replication area and the detention pond, because that was what was in the order of conditions. Both need to be done by November 30th, 2022.
Very good point.
Yes, Mike?
The expectation is that we can sign off, or maybe we won't sign off for 2 years, I don't know to see that they take, but the expectation is by November 30th, the project will be completed, and
Well, we'll.
barring that, it would be a violation of the
Planting.
order of conditions.
That's right.
And they've had ample time, requested ample time, given ample time. An extension is not likely to be granted. So they'd be in violation, and I guess we have a violation protocol. and I'd like to
Exercise.
execute it. Very good, good
Well,
work.
there are several items in the conditions that were written by Tim that were included in the Woodland as the latest order of conditions. And there were certain soil minimums that had to be included. 75% of the surface area had to be reestablished. The planting, so they really need to come in and explain that all of these items have been, I don't know what this picture is, but somebody needs to show up and explain what they did and assume that they, and then we'll check and see that they did it, but they need to tell us what they did.
And my comment wasn't for the commission, it was to be relayed to the engineer, so that our expectations are clear to him when he does come in. No surprises. And they have time, almost
30 days.
60 days,
Well,
right?
almost 60 days, yeah, because it's still October, but,
That's adequate. That's a good amount of time.
Well,
Yeah.
they've had years, so now it's reduced to 60 days, and maybe it's,
Still adequate.
yes. Point being, they should know the repercussions of not
Agreed.
not
Agreed.
fulfilling the obligation of the order of condition.
Okay. Okay.
So you also do have, like Michael was referring to on this site walk that only a couple were able to make. I think it was just Joyce, you and Michael, right, at Fitchburg Airport. Sorry.
yes, you and I and Mike, we did the Fitchburg Airport, that was their completion of their project.
Right. So they are asking for a certificate of compliance for the commissioners who weren't there. We took a walk into the rather large replication area over close to the Nashua River off of the side of the runway. We were accompanied by a wetland scientist from GZA who's working for the airport, and also an airport employee, because you have to be escorted wherever you go there. And I agree. Mike said the word lush earlier, and it certainly was. It had really taken very, very well.
Commission members, I intend to sign off on that request. And Chairwoman Tracy was there months ago prior to the restoration, and there was some weak spots in the restoration area, and they've since been addressed, and a really vibrant planting schedule. I suspect everybody here would be happy with the work. And I've seen a few. That was well, really took off in spite of our drought.
And Mike, no invasive plants that you observed?
A hint of purple loosestrife, but I confused it with another wetland plant that's also purple in color but had a different leaf pattern.
Right.
I got an education from the fellow that was representing the contractor who did the work and did the area. So he pointed out a lot of plants that were foreign to me, but pricing, $100 a pound for wetland seed because it's hand-picked. And then he pointed out a lot of the plant life that I guess I've seen before, but I didn't know what I was looking at. What else he gave us?
Tim, one thing that I thought was interesting, there was purple loosestrife there, but all of them, the wetland scientist held up, and all of them had little bite marks in it, little holes.
Right,
Remember?
they get a moth that
There's
eats
a
them.
particular beetle
Right.
that only eats purple loosestrife, and they have first
Introduced it.
developed it over in England like 50 years ago. So they
It's like a salad bar.
they import this particular kind of beetle that only eats loosestrife, and that's a way of keeping the population down.
Mitigation factor.
Yeah.
Yeah, and because he was looking at the leaves to see if they had, been eaten somewhat, and that's how they can tell there. And that controls it within the entire area. It was a
Right.
pretty interesting walk.
Yeah, true.
So based on what I've heard, I'm willing to approve or go along with a motion to approve the certificate of compliance, because it sounds like they did a terrific job.
They,
I think they did,
Ralph.
Ralph, and I think it's a wise decision of yours.
So is that a motion? Yeah?
Pass
Sounded
it.
like a motion.
Yeah, it did have that hint to it. So do I have a second?
Yeah, second.
Second.
Call the roll here. Joyce? Commissioner? Aye.
Aye.
Commissioner Donnelly?
Aye.
Ralph?
Aye.
Mary?
Aye.
And Commissioner Bro, I vote in favor as well. Aye.
And since we actually have 4 live bodies
Might
at
as
a
well
quorum
sign the
here.
document here. Huh?
Right, and then we'll be done with
Are there
that.
any other projects that we should be following up on?
Well, prior to your time, Joyce, but 900 Fisher Road, it was Thea Durling, Mary Chapin Durlings?
Yep.
It was, yeah. Long driveway. This goes back about 4 years ago, well pre-COVID. Order of conditions for a single-family house. That has been constructed. I saw the applicant, the application for a certificate of compliance, for an occupancy certificate. But I do want to check. It's a long driveway on the northerly side of Fisher Road, just to make sure that things have been stabilized there. It probably is premature for a certificate of compliance at this time. Another thing that was mentioned at last month's meeting about a badly needed septic repair at I forgot the address, but it's on Ashby, 762.
751, 752?
762, I think, Ashby State Road. Met out there, thank you, Mark, with Howie Sumner, who was doing the work prior to, he showed where the line of hay bales were going to be. The last couple of times I've been up that road, Howie's been doing the work. It really was an emergency situation. They had a sale, but you cannot use the septic system for any person who was living there. So work is ongoing. I'm pretty sure it isn't quite complete yet, but that's one. That was done through an emergency order rather than a request for determination that was going to be filed.
I missed you out there. I went out there. You went out in that afternoon. I went out. I took a look at it. It was kind of a boilerplate, folks.
Yeah.
So I know I will have to step away, but the other commissioners can discuss what about Danufil.
What about, sorry?
Well, let me,
The solar field.
Oh, Mad River,
Mad
yeah.
River.
I've had to have a conversation, in fact, this afternoon, with Attorney Barrett, who's representing them. They are getting ready to hire someone in order to, first off, remove some of the hazard trees closest to the neighbors, particularly on Ashburnham Street. But they're looking around for a good contractor to do that work. And I know that it has been delayed because it's been a few months since that was approved by both the commission and the planning board. So I'll get together with John and John DeNeuville, the property owner, to see if we get at least a work schedule and what time work would be starting there. But the first thing that we're going to try to get on board was a forester out there who to remove those hazardous trees closest to butters.
Has the order of conditions been registered at the Registry of Deeds? Tim Smith had worked on it.
It has, no, for Mad River?
Yes.
No, I don't believe it has been.
So what do we do about that? I mean,
There's a host of conditions that may or may not have been met, and that's one of them. Is there ever a time limit as to when it would be registered? All of them need be. Is there a time limit placed? Does this commission place a time limit on registering them? Clearly, they haven't.
There isn't.
Clearly, they're not in violation if they haven't done it yet. They could do it tomorrow, but it had to be done. And there ought to be a time limit, and it ought to be immediate upon receipt of the order of conditions.
which was in April.
Or was,
April 3rd was written up. So we're 8 months later. As I said, that's significant. It's not a violation if they do it tomorrow unless we have a time limit. So I hope that I hope the commission would consider a time limit. Secondly.
Well, maybe you
Mike,
have a
hey, so-
standard. Sorry, Tim, go ahead.
Yeah, no, they should record the order of conditions before they start work.
Is it a law?
You put it as a special condition, and I think
Going
that's been
forward? Okay,
discussed.
that's my point. If we're going to do that going forward, let's do it. Let's make sure that we do it. And right now, it still has to be done, but it's not a violation, okay? But it's part of the order of conditions, so they're going to have to do it before we sign off. I think more importantly, right now, number 3 of the special conditions was schedule of the restoration shall be provided by the applicant. The activity shall commence in the spring and completed by November 30th. From what I just heard, they haven't hired a person, so they have 60 days to perform. 60 days to perform, and the commission shall consider issuing an enforcement order and fines if it finds a good faith effort was not made to complete the restoration during the 22 growing season. Establishing vegetation in the next 60 days is going to be a challenge, and I think it flies in direct non-compliance of the order of conditions.
Mike, didn't you say November 1st a moment ago?
November 30th.
Oh, 30th? Okay.
Yeah. So they need, first of all, a quarterly report. It's been 8 months. 1/4 of that is 2. Okay, so do we have that? In which case, the restoration shall commence in the spring and be substantially complete. At any rate, yeah, they haven't reported quarterly. That's in violation of the order of conditions. So we write these things for a reason, and when they're not adhered to, maybe sometimes you let the little guy slide, sometimes you get the big guy. I don't know, but I don't come here once a month to. Well, I jibber jabber too much, but I hope that we get some results out of it. That's all. Progress report to the commission on a quarterly basis, number 5. Seeding shall be watered. Last month was the time to seed, and maybe they got some reprieve with global warming and all, and they can get seeding in. But substantially complete, I guess I'll leave that to everybody here's best judgment. They need to be told. Michael, I hope that you'll tell them when they're reminded that they've got to come in for November 30th, that the commission will play in hardball.
Yeah, I mean, that was a big violation. And there was like watershed that was going on off of the property into neighbors' property. So, you know, like they've been dragging their feet for a long time with that one. So, yeah, I'm playing hardball with them too.
Okay. We'll do one thing. There was a request for determination at last month's meeting, determination of applicability for Fitchburg's wastewater for a CSO removal on various streets, but mainly Main Street, Chestnut Street, kind of further uphill from the Upper Common. Didn't realize at the time that we didn't have the document to signs, but since we do have 4 live ones here, well, that's going around, just so you know, I think most of you know, the planning director, Tom Skorowski's last day will be this Friday. He's taking another position in the city of Revere as planning director there. They have the position, actually they have the position advertised already. You folks knew Nate LaRose, rec director who left the services of the city several months ago, and he's a stay-at-home dad now. His replacement was hired by the Parks Board, just started yesterday. Well, started, Monday. Was his first Parks Board meeting last night. He has a background in a lot of the programming things. He was the AD at several area high schools. Lunenburg most recently, North Middlesex. So I think I get a good impression from him. So I'm sure we'll be dealing with the parks.
Hey, if I can revert back to Mad Solar, they placed a bond, number 14, a bond was to be placed on the project. And if that's the case, should the applicant fail to perform, complete the restoration in a timely manner, the commission may use the bond or money to complete the restoration. Those things that I've highlighted, I hope that they're highlighted, Mike, to Mad River. And on November 30th, if they're not going to do it in a timely manner, 8 months is a timely manner, we reserve the right they accepted the order of conditions, they didn't appeal it, to go in and finish it ourselves. And we hire out and pass the cost on to them. And they don't have any say about it. But on November 30th, they can either defend themselves or give us a check for the future work that we're going to hire out to do.
Has the bond been filed? How does that work?
I'd have to try. I think we're getting an estimate from DPW. Let me check. I'll have to check. Just a couple of things that I found this. Remember the John Fitch Highway, 105 John Fitch, the Dunkin' Donuts?
Yes.
Work will be starting out there pretty soon. I'm gonna, sometime within the next week or two, the site contractor reached out to me, so we're gonna arrange a pre-construction meeting out there so everyone knows, what the approved plan is and what the orders of conditions are. What else going? I got a call from a person who does some work for Mock. One of their main buildings at 601 River Street.
Yeah,
it's
right
at the
after the
intersection
bridge.
of Wallace and River.
Yep.
If you've ever been up behind there, there's a fairly large parking area and then a dam. And when water is coming off of that hill, really from that subdivision, Bishop and Castle off of Westminster Hill Road, there's a neat little waterfall. Anyway, that stream continues on down, culverted under the parking lot. And years ago, when that was still an office, I think, for the paper mill that was there, one of the paper mills in town. Anyway, they planted a few decorative trees. Some of those trees have gotten very large and have since died. And they are pretty close to the parking area, the employee parking area for Mock. So they want to take those 4 trees down. I met out there with a gentleman who is not taking the trees down, but will be sort of overseeing the project. They have Linwood Tree signed up this Saturday in order to take that down. Saturday makes sense because there's no employees there. But to me, I thanked them for notifying us without going ahead, but the trees are clearly down. I don't think they need any further special filing with the commission. So if you folks want to go out and take a look, it's pretty obvious. It's 4 big old dead trees.
Okay.
Mike, another item you don't have on the agenda, but it was in the Dropbox. This is a very long, complicated request for certificate of completion by MBTA at the West Fitchburg train station, and I, for one, am not going to review that, however, hundreds and hundreds of pages of plans, and I can't make heads or tails of it just browsing through it. We would need somebody to take stock of it and tell us whether the work has been done properly or not.
Right. I think the gist with that, actually, there's 2 separate orders of conditions, one for track work and one for the station itself. And if I remember, back when we were all doing these only online, there was a representative from the engineer for MBTA. The only thing that needed to be done was the installation of, I forget however many, stone check dams aside the railroad. But I'll reach out to the engineer. Yeah, I probably put that in the Dropbox in error because it didn't have
The
it
cover
listed.
page says that the order of conditions originally was issued in April of 2012.
Yeah, I think it was, they were all issued around the same time when they were first proposing Wachusett Station to be built. yeah.
Ralph, to your point, if you're not going to do it or feel overwhelmed, and we hire out, can we expect to be billed by a third party and pass that bill on to the MBTA and be paid?
Well, I think maybe the best thing is have the MBTA's engineering consultant give the commission the story. You know, here are some pictures of how
Mike,
things have been.
shouldn't they provide a written statement that the work was completed in compliance with the order conditions?
Yeah, yeah,
They
should.
did in like a one-paragraph letter, Tim.
I think.
But then it was accompanied by hundreds of pages of plans.
Okay.
Let me track that down, okay? That was some time ago, and this was discussed previously about whether to, yeah, let me track that down. I know there's an email string from the MBTA's people, HNTB, I think.
And for what you know, Ralph, it warrants a third-party review.
Well, I'm not saying that, Mike. I'm just saying that I can't evaluate it, and I doubt any of us want to try. It would be more appropriate, probably, for what Mike O'Hara is recommending, that they come in and at least explain themselves so that they can, distill it down to something we can understand. And then, if needed, I suppose we could hire some third party to oversee the review, but maybe that's not necessary, or maybe Nick Erickson's able to say, yes, they did what they were supposed to do. Not to put a burden on you, Nick, but it's beyond us, I think.
I could certainly assist and do some analysis. I haven't visited the site recently, so I'd have to do that.
Yeah, we'll
Okay,
put it
thank
on
you.
for, make sure we have the proper documentation, the request for determination, the engineer's certificate, that things have been done according to the plan, and we'll put it on a future agenda.
Thanks, Mike.
Thank you.
I'm going to motion to adjourn this evening's meeting. It concludes our meeting for the October 2022. Our next meeting is November the 2nd. That's a Wednesday. It's always the first Wednesday of each month, as a reminder. Do I have a second?
Second?
All in favor? Aye.
Aye.
Concludes our meeting. Thank you, everyone.